Picture this, you're in HR and it's Monday morning. You got an email from an employee who's been with the company for years. They're usually dependable, but today they need to take a sudden leave of absence. No explanation, just that it's family related. Now, you're left to figure it out. Do they qualify for time off? How long will they be gone? What about their job security? That sounds familiar, right? This is a classic scenario where the Family Medical Leave Act, or the FMLA, steps in. The FMLA is a cornerstone of employee rights in the U.S. workforce, providing eligible employees with job-protected leave for certain family and medical reasons. But how did we get here? Today we're diving into the history of the FMLA, from its rocky beginnings to the essential protections it offers today. So where did it all begin? Well, the story of the FMLA starts long before its signing in 1993. In fact, the idea of a federal law protecting family and medical leave had been floated around since the 1980s. At that time, more and more women were entering the workforce, and the balance between work and family life became a growing concern. However, employers weren't always on board with the idea of unpaid job-protected leave. Now let's fast forward to 1993. This year, President Bill Clinton signed the FMLA into law on February 5th, 1993, after years of legislative battles and two previous vetoes being given by President George H.W. Bush. That law went into effect later that year, guaranteeing eligible employees up to 12 weeks of unpaid leave for specific family and medical reasons. Initially, the FMLA applied only to companies with 50 or more employees, and many argued that was too narrow in scope. Over time, amendments have broadened its protections, such as allowing for military family leave and clarifying the definitions of what a serious health condition is under the statute guaranteeing that leave. Let's talk about which employers must comply with the FMLA and which employees are eligible for this leave. Not all employers are actually covered by the FMLA, a common misconception. Employers must comply if they meet these conditions. The employer has 50 or more employees within a 75-mile radius of where the employee requesting the leave works. This can include private sector employers, public agencies like schools, and government employers. Small businesses with fewer than 50 employees are generally not required to provide FMLA leave. However, some states have their own family leave laws that may impose additional obligations on smaller employers. Now, we must also state employers may be bound to FMLA protections to the extent they promise them in employee handbooks, policies, or in employment agreements. So if an employer is not eligible for FMLA under its statutory terms like those we just discussed and does not want to provide those benefits anyway, it is crucial that they do not otherwise offer those FMLA benefits or state that they provide them in a handbook. We see this all the time where we review a handbook and an employer, they have promises of FMLA leave in that handbook because they had ChatGPT write it, or they got a form off the internet and it just automatically contained the FMLA requirements. But that employer was not actually otherwise required to give those benefits because they didn't have 50 or more employees within a 75-mile radius. But because they put them in a handbook, they're now there's an argument there that they're now contractually required to provide those FMLA benefits. But what about employees? Well, here's who's eligible for FMLA leave. The employee must have worked for the employer for at least 12 months. These 12 months don't need to be consecutive, but breaks of 7 years or more may restart the clock unless certain exceptions apply. The employee must have worked at least 1,250 hours in the last 12 months leading up to the leave to otherwise also be eligible. So employed 1 year and working 1,250 hours during that year. And as mentioned earlier, the employer must have 50 or more employees within a 75-mile radius of the location where the employee works who is the one requesting the leave. If an employee meets all these requirements, they're eligible for up to 12 weeks of unpaid leave for qualifying reasons. These reasons typically include things like the birth or adoption of a child, an employee's own serious health condition, or caring for a spouse, child, or parent who has their own serious health condition. But how much leave is allowed? It is 12 weeks of the average number of hours the employee typically works per week. So not every employee is going to have 12 weeks of 40 hours per week of leave. For a part-time employee, for example, who's only working 20 hours a week, it's going to be 12 weeks of 20 hours per week of leave. This can be a complex analysis, so consult with your HR advisor or your own attorney if you have specific questions regarding how much leave an employee is entitled to. But even with its protections, the FMLA does have its limits. It's unpaid, and not everyone qualifies. It's a law designed to balance the needs of employers and employees. But it also raises the question, should the law expand? Should leave be paid? These are conversations that are still happening today, especially during this presidential election year. While they're using their FMLA leave, employees may have the opportunity to use accrued PTO or sick leave while they're out on FMLA. And some employers actually require such use, as is typically recommended by their attorneys. Employees may also be eligible for short-term and long-term disability benefits while they're out on FMLA leave, but that's a conversation for another day, and you're gonna have to consult those plan documents to ensure whether they actually have eligibility. Let's talk about some of the important specifics and misconceptions for the FMLA. First, another critical element of the FMLA is its protection against retaliation. Under the FMLA, it is illegal for an employer to retaliate against an employee for requesting or taking FMLA leave. Retaliation can take many forms, and here are a few examples. Denying a promotion or raise to an employee who took FMLA leave, disciplining or demoting an employee for taking FMLA leave, harassing or intimidating an employee to discharge them from using their FMLA rights. If they come to you and says, hey, I need FMLA, and you're like, oh, too bad, so sad. Oh, by the way, for asking, we're gonna fire you. You're gonna run afoul of these retaliation protections. Terminating an employee while they're on FMLA leave or shortly after they return can also be red flags for retaliation depending on the circumstances associated with the layoff or termination. In fact, if an employee believes they've been retaliated against for using FMLA leave, they may be able to file a complaint with the Department of Labor or even pursue a lawsuit against the employer. Second, upon request by an employee or when an employer has enough knowledge to know that a leave may be protected by FMLA, the employer, typically through the HR department, should provide the FMLA forms to the employee proactively and potentially even their healthcare provider to complete. The Department of Labor publishes standard template forms for FMLA that employers may choose to utilize. Importantly, there's no magic FMLA words that an employee needs to utilize when requesting this leave. An HR department or manager or supervisor having sufficient knowledge to know that such leave may qualify under the FMLA is enough to trigger that form delivery requirement. Third, if an employee has health insurance through the employer, an employer cannot typically terminate these benefits during that FMLA leave, but the employer may require that the employee to continue to pay their portion of the premiums. Fourth, employers that are required to provide FMLA benefits must post the FMLA poster in the location where their other posters are provided. We all know that break room filled with, tons of posters discussing all those employment laws. This is what we mean. Fifth, there is no undue hardship exception under the FMLA, unlike the ADA. Meaning, unless some other rare circumstances exist, if the employer has to provide FMLA and the employee is eligible, FMLA benefits must be provided. It doesn't matter that you need someone to be in that position for the 3 months that they're out on leave. You might have to put someone in that position temporarily, but that employee is going to be entitled to that position upon their return. Sixth, employees may have intermittent FMLA leave available to them, meaning they use leave based on hours in a day or days of a week rather than one continuous 3-month leave. Employees may need this time in the event of a flare-up of symptoms, to attend doctor's appointments, or among other occurrences, and this intermittent FMLA leave is also protected. Seventh, the FMLA requires leave for serious health conditions only, typically meaning inpatient care or continuing treatment by a healthcare provider. Minor ailments and illnesses that can resolve quickly, think of the flu, the common cold, basic infections of COVID are not typically covered by the FMLA. Eighth, when an employee is ready to return from FMLA leave, they must be permitted to return to their same position or an equivalent position with equivalent pay, benefits, and other terms and conditions upon their return to your workplace. Ninth, there is an intersection between the ADA and the FMLA that we need need to discuss. If an employee's condition would also rise to the level of being a disability under the ADA, companies need to follow both processes at the same time. They'll run in parallel. This may mean that after FMLA leave is exhausted, the employee may be entitled to additional leave or workplace accommodations under the ADA. But remember, the FMLA, unlike the ADA, does not have an undue hardship exception that employers can fall back on. 10th, some states have their own versions of the FMLA that provide for protections and leave greater than those provided by the federal government. Therefore, always check with your local HR team or attorney with questions as to whether your state has a separate FMLA statute that otherwise imposes additional requirements on you as an employer. So the next time you face an FMLA scenario at work, remember this. This law was decades in the making and is still evolving. Whether you're an employer, an HR pro, or an employee, understanding the FMLA's history and who it applies to helps you navigate its complexities and appreciate the hard-fought protections that it actually offers. That's all I got for you on this week of Employment Law After Hours. We'll see you again next time.